Folks have long believed the Supreme Court was the steadfast guardian of your right to carry. But things have shifted, just not in the way you'd expect. This fresh 6-3 decision upended concealed carry laws. And here's the surprise no one anticipated. The leading voice wasn't Thomas, Alito, or Gorsuch. It was Justice Amy Coney Barrett, who teamed up with the bench's three most liberal justices, Kagan, Sotomayor, and Jackson. Together, they crafted a fresh legal test under the Second Amendment, and many concealed carriers are left in the dark about its implications. Even if you've been dutiful, trained, and think you're on the right side of the law, you might find yourself in a legal bind due to this ruling. Some states have lost the ability to ban carry on private land, while others gain power to designate new zones where permits hold no weight. This change isn't coming, it's already here. Let's untangle this. No media spin or political bluster, just the plain facts vital to every gun carrier in America. The unexpected uproar. The Supreme Court's recent actions have left both gun rights and control groups puzzling over the win-loss scorecard. And this confusion is telling because the ruling came in way off the expected course. Gun owners of America lashed out, calling it a betrayal of constitutional values, stating the court gave states pathways to obscure the Second Amendment with regulatory layers. They see it as plain judicial overreach. But here's the kicker. The NRA actually applauded Justice Barrett's decision, considering it a balanced method upholding core carry rights while allowing states room to safeguard public safety. It's rare for such a split between these pro-gun groups, and it signifies a monumental shakeup in gun rights advocacy. On the flip side, the Brady campaign couldn't tether their message. Initially, they lauded the court's green light for new sensitive zones, but reversed course to critique the lift on private property bans, an amendment that reopens concealed carry in countless private businesses. The most astonishing turn, though, saw Justice Clarence Thomas, usually reserved outside court, publicly denounce his court's ruling. He labeled it a perilous drift from originalist interpretation and cautioned this new standard grants unelected judges undue power over carry rights. That's a rare moment, a sitting justice criticizing a colleague's decision out loud. Meanwhile, Democratic lawmakers are divided. Some commend Barrett's balancing approach. Others decry her removal of statewide bans. Republicans, frustrated, find a justice they appointed reshaping the Second Amendment's legal structure alongside three liberal justices. Even seasoned constitutional law professors admit they've lost their teaching compass due to the obliteration of the time-honored liberal-conservative court divisions. This was no mere legal ruling. It was a tectonic shift in political discourse. Next, the looming legal conundrum, state by state. At the moment, governors, attorneys general, and state legislatures are scrambling. They've got 60 days to overhaul decades of concealed carry statutes or face automatic federal blockades. 12 states had large chunks of their gun laws erased overnight. These states had attempted to ban carry on all public access private property. Now that stands unconstitutional unless clearly posted with signs. Meanwhile, 8 other states received the autonomy to enforce new carry bans in sensitive spots like schools, stadiums, transport hubs, and government quarters, courtesy of the court's Fresh Balancing Act. New York sprung into action, summoning an emergency legislative meeting within hours of the judgment. California is on a fast track to relabel numerous territories as high risk to restrain carry rights before the 60-day period lapses. Texas trod a different path, broadening constitutional carry in reaction to the verdict, citing it as justification for doing away with what they dubbed outdated curbs. Massachusetts is fortifying its stance, pushing for broader carry prohibitions in public domains, even aiming to define downtown areas as sensitive zones. Similar moves are seen in New Jersey, crafting what could become the strictest post-verdict legal framework. The chaos only deepens. Some states are seeking emergency clarification from federal courts on applying this new legal benchmark, while others burn through millions on constitutional consultations to avoid dual lawsuits from gun owners and control advocates alike. Florida took decisive action, wiping out all carry permit prerequisites, arguing the new standard supports permitless carry as long as certain safety provisions are observed. Amid all this, carry permit holders find themselves caught in the crossfire. The legal landscape shifts quicker than states can churn out updates. Some restrictions are obsolete, others persist, and few can tell which rule applies where. This isn't merely a policy transition. It's the most turbulent phase in state-level gun law since the Republic's dawn. If your horizon involves state travel, grasping where the legal sands have moved is vital, as a misstep could mean charges under a law altered overnight. Sweeping alterations to carry zones and permit reciprocity have arrived. This ruling didn't just alter a handful of state laws, it fundamentally revised where you can legally bear arms and how your permit functions across borders. Many are unprepared for the real implications. Starting with the private property pivot, in states that formerly barred concealed carry by default on commercial private grounds, that era is over. From now on, unless a business boldly states firearms are banned, your carry is permissible indoors. This alone rolls back carry limits in regions like New York, Maryland, and Hawaii. But the snag lies here. Justice Barrett's opinion devised a novel cadre of approved restrictions labeled sensitive areas, prompting states to hastily capitalize. Already, lockdowns cover 1,000-foot perimeters at schools, transport nodes such as subways and bus depots, large venues like arenas or theme parks, and government offices, including courts, license bureaus, and social service spaces. Beyond that, various states are angling to declare high-density commercial zones like shopping areas and downtown spots as off-limits, contending heavy traffic poses significant safety risks. And the scope extends further. The new legal framework authorizes states to mandate extra training, carry insurance, or special permits for armed access to particular zones, instituting a tiered carry system. Your basic permit might grant grocery store access, but falls short for arenas or transport unless additional stipulations are met. Such a model never existed before, compelling each concealed carrier to discern their permit standing based on destination and local laws. Turning to reciprocity, the ruling mandates states honor out-of-state permits unless they prove a compelling safety rationale against it. While promising in theory, the devil hides in compelling, as each state interprets this autonomously. Some may welcome nearly all permits, while others draft regulations to refuse reciprocity founded on crime rates, population data, or policy leanings, which means even a nationwide valid permit could be invalidated based on perceived training or vetting inadequacies. Here's the crux. You now wield expanded rights across most private enterprises, but face a burgeoning list of varying restricted zones. Crossing state boundaries demands checking laws lest you unwittingly enter a newly felonized carry zone. The newly minted practical carry standard clarified. It's time to shed old notions of how the Second Amendment plays out in courtrooms. Justice Barrett's decision has eclipsed the old Bruin test, ushering in an innovative legal doctrine. Dubbed the practical carry standard, it shifts the burden of proof, altering the judgment of every carry case from here on out. Under the Bruin precedent, courts gauged whether a gun regulation existed around 1791. Without historic backing, the law risked being scrapped. This bestowed a hefty legal edge to gun owners, but Barrett dismissed this methodology. Her revised standard asks not whether a law echoes the past, but whether it obstructs your fundamental right to self-defense. This revolutionizes the landscape. Now, states can assert a gun law holds water if it balances your carry rights against genuine safety concerns. The court needn't confirm historical alignment, only the regulation's reasonableness, specificity, and its non-infringement on your defense rights. Justice Barrett pinpointed 3 criteria to satisfy. First, the regulation must address a pressing government interest. Second, it must be intricately aligned with that interest. And third, it must preserve alternative avenues for exercising Second Amendment rights. This balancing tool offers states a new legal playbook. Under Bruin, most regulations faltered. Under Barrett's paradigm, they may thrive. These cover mandates for training, insurance, location-specific bans, and beyond. Justice Thomas stood aghast, critiquing the court for deserting Bruin's constitutional method. His dissent warned this fresh standard paves the way for judicial favoritism toward state power by merely classifying issues under public safety. Justice Kagan countered, voicing support for the ruling. She argued it enables courts to weigh contemporary realities while safeguarding core arm-bearing rights. As she sees it, the Constitution shouldn't obligate the government to overlook modern risks absent in the 18th century. Legal pundits are calling this the foremost shift in Second Amendment interpretation since the New Deal. It's not limited to carry permits. The ruling outlines a new blueprint for reviewing every gun regulation, from magazine plays to confiscatory laws and waiting intervals, which means gun owners now operate under revamped legal conditions, witting or otherwise. Lastly, why this 6-3 ruling reshaped everything. This decision did more than revise legal norms. It leveled assumptions about the political landscape around the Second Amendment. The largest shock wasn't the court's declaration, but who voiced it. The majority opinion, reshaping concealed carry law across the land, came from Justice Amy Coney Barrett. Yet she wasn't alone. She partnered with all three of the court's liberal justices. That's Barrett, Kagan, Sotomayor, and Jackson, uniting to construct a new legal framework for gun rights. Meanwhile, the dissenters were the three staunch conservative voices, Thomas, Alito, and Gorsuch. This twist shattered expert expectations. Barrett, having been appointed by a Republican president and aligned as a conservative originalist, fashioned a balancing test that offers more leeway for government regulation of carry rights than any post-Bruin decision. Thomas, the Bruin author, unleashed a stinging rebuke, accusing the majority of straying from the Constitution's historical pathway. He saw this as ceding undue power to judges and gave states room to thin out essential gun rights under safety pretexts. Yet Barrett justified her perspective as a pragmatic fix. Her stance was that while the Second Amendment upholds carry rights, it doesn't assure bearing arms everywhere, anytime, sans limits. Her framework aims to counterbalance that core right with valid governmental interests. The result is a politically scrambled, modern Second Amendment ruling. In a first, the court's liberal segment supported widening gun rights, not from newfound Second Amendment support, but because the framework grants states more sway over gun placement and timing. This pivot has triggered ripples across state capitals, academic circles, and gun rights groups nationwide, leaving many grappling with how to interpret this new coalition. Conservatives find themselves divided, liberals conflicted, and legal minds struggle to teach this case. What you're witnessing isn't just a Supreme Court decision, it's a constitutional reset. The rule book's been rewritten, and every concealed carrier in America now plays a new game. This ruling doesn't simply recast how judges appraise the Second Amendment. It shifts the very earth beneath each gun owner. Concealed carry rules just became more accommodating in some quarters and intensely constrained in others. And your location or travel plans might mean the difference between lawful immunity and a felony charge. For years, we've strived to ensure the right to carry stands not just in writing, but in practice. This struggle has stepped into a new legal epoch. Truth is, most won't keep pace unless it's broken down state by state, zone by zone, decree by decree. That's where we come in. If this breakdown helped, do me a favor. Hit that like button, subscribe to Beam Firearms, and drop a comment about your state's reaction to the ruling. Stay vigilant, abide by the law, and value your freedoms.